Hello, everyone, and welcome to Mediator Locator. We're a national mediation service working across all sectors and covering the whole of the UK. We currently partner with 12 leading law firms, and we're expanding our network all the time. Our panels include 30 top mediators, all of whom are qualified lawyers, many at partner level, and many have very long experience behind them. Many of our mediators are also leading specialists in their fields. Mediation is all we do, and we're true specialists. We're not just a directory, so it's our specialism. And we recommend the right mediator for you and for your case, and we take the hassle out of the selection process. It's a simple, flexible and hassle-free service, and we have both online and in-person mediations, and we all believe mediation is the future of dispute resolution. So today we're going to have a general chat about mediation issues, and I'll be putting some questions to our panel of expert mediators. Pleased to welcome Claire Kitchen from Ellisons Solicitors and Jeff Lewis from Brabners Solicitors. So let's get started. Claire and Jeff, maybe Claire, start if you could introduce yourself and say a little bit about who you are, and then move on to Jeff. Thank you.
Thanks, Stuart. My name's Claire Kitchen. I have been a solicitor since, 2001. I am an expert, allegedly, in commercial litigation. I also deal with a little bit of defamation, but my main focus for the last 25 years or so has been civil fraud. So either acting for or acting against people that perhaps have been accused of acting in a dishonest manner. One of the things that I have found out in my general commercial practice over that last 25 years is that mediation needs to be used more. Even though it did grow a lot after 1999 and the civil procedure rules came in, it's grown in importance, and I think it should be used even more than it actually is.
Thank you, Claire. I totally agree. Jeff?
Hi. This is a real oh gosh moment because I qualified as a solicitor in 1989, which tells you how old I am. And since then, I've practiced as a commercial litigator for all of my career. I've been at Brabners, my current firm, for 20 years, dealing with commercial disputes. Some property disputes, some contract disputes, shareholder disputes, partnership disputes, and professional negligence. Really, as I say to people, most things that companies can find to fall out about. I've also practiced as a mediator for 20 years, in fact about 23 years actually. And I also have a number of judicial roles. I sit as a deputy district judge, and as a member of the FA, the Football Association Judicial Panel. And like Claire, I think that mediation is a really valuable tool, and certainly didn't used to be used as much as it should be. I think maybe that's changing a little bit, but I think there's always scope for a greater use of mediation.
Yeah, absolutely. I mean, it's crazy. I just thinking, I didn't introduce myself, but I qualified as a barrister back in 1994, so 31 years ago. And it often feels like yesterday, but the time just flies by. And I did a lot of dispute resolution. I actually worked for a large construction company, and I got into all sorts of the tangles that you think you were alluding to there, Jeff, with issues for a large company. So sadly, I never used mediation whilst working for my former employer, but I think that was a big missed opportunity, something now we can hopefully correct. But if we can turn to a few of the questions, and thanks for the intro. The first question is just what drew you guys to mediation? I mean, you both got long careers as experienced, seasoned litigators. What was the catalyst that turned you towards mediation? And feel free to go. Claire, why don't you start?
I think it was I saw, as I did qualify just as the CPR was coming in, I think it was seen at that time as quite a new thing, although it had been used sparingly before. So I kind of grew up with it. I was introduced to it. It was seen as a big thing when we were going between the two systems, and then when you actually see it in practice, it's a very interesting way of resolving disputes. you can it's the way that things can be resolved that couldn't be perhaps via litigation in the courts. And I became a convert, I think, on my very first one acting as a solicitor for one of the parties. It is just a completely different way of acting than it would be in a contentious adversarial situation such as litigation.
Yeah, and then you mentioned the CPR. For those people that don't know, that's the civil procedure rules, which govern the whole of the structure around civil litigation. And I think within the civil procedure rules, there's a process called the pre-action protocols, which is obligations you're supposed to follow before you litigate. And there's kind of a lot of pressure now to follow those avidly. And if you don't, you may get a cost sanction. I think, Jeff, you probably know more about that from your judicial role. But buried within the centre of the pre-action protocol rules is a requirement to give mediation proper consideration. So, what pulled you towards mediation, Jeff? And in your experience sitting as a judge, do you see people properly complying with the pre-action protocols, or is it a little bit hit and miss?
Yeah, well, just dealing with the first part of that question first. As Claire said, mediation became more popular and more part of the standard armoury of a litigator's practice in 1999 when the civil procedure rules came in, and I became accredited as a mediator in 2000, which perhaps to some extent shows that I'll jump onto any passing fad, but I did think that mediation was one of those things that was going to be here to stay, and so it's proved, obviously, and it's really become a lot more prevalent. I think for me, the big attraction of mediation then and now is just that you get you have the conversations with the other side at the right time. And you may know, Stuart, from your days as a barrister in the 1990s, what used to happen was the parties would get to court, and on the morning of the court, you'd spend hours shuttling between rooms, and a deal would quite often get done. And you think, well, why have we got here? Why wasn't this conversation taking place 6 months ago, 12 months ago, 18 months ago? And totally. I think for me, the big appeal of mediation is to avoid that frenzied, frantic negotiation on the morning of the first day of the trial. So that was the big pull for me. In terms of the second part of your question, I think it's variable as to the extent to which parties comply. I think that there is still a lot of people saying the right things but not necessarily doing the right things. One of the things that I do in case management conferences in suitable cases is to urge the parties to consider alternative dispute resolution and mediation in particular, and everybody says the right things and says, yes, of course, well, that's very helpful, Judge, and we'll certainly take that on board and we'll report that back, and if the clients are there, if the parties are there, I'll address them directly and extol the virtues of mediation. And they then leave the courtroom, and I think, well, maybe that will settle. And then 3 months later, it's back in court, and mediation has either not been attempted, or has normally not been attempted, and occasionally it's been attempted and failed.
Yeah, no, when we met last year, one thing that struck in my mind when we were talking, you said that in the past judges would say give consideration to mediation, and the parties would go, or the parties' reps would go, absolutely, yeah, we will. And then go off and perhaps ignore it. But now, I think if I correctly remember it, you said now you're saying, well, what evidence have you got to show me that you've actually actively considered mediation, which I think is a nuance, quite a powerful nuance, because if you're bearing down on them, particularly parties as well in court, that may have a strong effect. So long may it continue. And obviously, when you're sitting on the bench, you can't say, and you should use Mediator Locator for your mediation services.
If I could, I would, but sadly, that's not permissible.
Absolutely no, quite so. Second question I've got is, this is a bit of a silly one, but really, is there sort of one word or one question that jumps out to you when you start a mediation, the first thing that parties say? Jeff, you go first this time.
So what if there's one thing that
If there's one word clients often say, or one thing that they say that sort of makes you smile or is typical for start of a mediation?
I think that probably the one thing that every every party says, and where I try not to raise my eyebrows, is they say, we're here to do a deal, and it's not the money, it's the principle, and the only reason we're here is because of them." And both
Right.
parties tell you that, um, and you sort of have to say, we have to resist the temptation to say, well, I've just heard that in the other room, and I've heard that in every mediation I've done uh, since the year dot. Um, but yeah, I think that's the sort of that's the phrase that I keep on hearing, and where I have to resist the temptation to raise my eyebrows.
Okay. Okay. And Claire, it's the same thing?
Similar, but there's always a reason that they've got themselves into a position where they've reasoned themselves into entrenched positions very often, and I
Yeah.
think it's the mediator's job to try and unravel that thinking very often in a way that it doesn't happen in court.
Right. Okay. That's interesting. Yeah, that's good. Um, this is a bit more a general question, but how do you feel preparing for a mediation differs from preparing from a court case? And I'll preface this. I did a mock mediation a little while ago with Tim Constable from Bates Wells, who was leading it, and it was for two university students at the University of East London. It was quite a nice session actually, and they were very interesting people and very engaging. And he was saying that when you prepare for litigation, you've probably spent the most money you'll ever spend in preparing the perfect case with documents, statements, and so forth. And judges are spoilt because they get presented to them the most beautifully prepared cases. Mediation's probably a little different. What are your experiences?
I think it's similar, actually, Stuart. To be fair, I mean, when you're preparing your bundles, you've got to make sure if you're going to refer to, documents, you've still got to have them in that bundle, because otherwise a mediator's not going to be able to advise if he's only got half a story or she's got half a story. From a client's perspective, I think it's very different in that it's that you're not going to be cross-examined. You are going to be able to have more of a free rein as to what you can say to a mediator than what you could understand. So I don't think clients are fettered, but from a lawyer's perspective, I think the work is still there to be carried out, and in order to get a decent result at mediation, I think part of that is in the preparation of the case to be put before the mediator and the mediation as a whole.
And do you find they're better prepared when the lawyers are involved, or when individuals are just doing it on their own, or does it vary much?
Well, my view on that is it usually is better if they have a good solicitor and or a good barrister, and that's the difference. I mean, I've acted for. There has been an uptick actually in litigant in-person mediations recently, and I think the problem is there as a mediator you can stray into legal advice if you're not careful, which you really, really mustn't do.
Yeah.
And that's when it's helpful to have a decent legal advisor on acting for the clients, because they can act as somebody that calms their client, reasons with their client, assists their client in dealing with the mediation and the knotty problems involved. However, conversely, you can get a really aggressive litigator, and to be fair, I think I've probably fallen into this trap when I was very junior, sticking up for your client, being the guard dog that perhaps isn't quite as conducive to a settlement as it should be.
Okay, that's helpful. Thank you. Jeff, what are your thoughts?
Yeah, I mean, just in terms of preparation and bundles, I have to say I find that as a judge, the bundles are often as poor as they are as a mediator. So it's
Okay.
not the case that that the judge does receive perfect bundles and perfect documents. But for me, the biggest difference between mediation and court in terms of preparation is that you're playing to a different audience. When you go to court, the only person you've got to impress is the judge. It doesn't matter what anybody else in the room thinks. It's what the judge thinks that matters. So everything that you're saying is addressed to persuading the judge to your way of thinking.
Yeah.
In a mediation, of course, there is no judge, but actually you're playing to the other side. What you want to do is to persuade the other side, and not necessarily the lawyers, but persuade the parties of your way of thinking. So it's a very different audience. And what a lot of people do, I think, in a mediation is they treat it as if it's a court hearing and start to persuade the mediator as if the mediator were a judge. And what I always say to parties when I speak to them before the mediation is remember that this is your chance. It may be your first chance, it may be your last chance to speak directly to the other side without what you say going through the filter of lawyers, without the other side's lawyer being able to say, oh, well, what it really means is X, Y, and Z. Here you've got the chance to address the other side directly. They will hear your words as they are being spoken. So make sure that you don't lose the opportunity. So I think it's the fact that it's a different audience that is the big difference for me.
Yeah. Okay. And do you find that with mediations you get lots of people turning up, or is it relatively slim on the numbers? I guess it varies, but what do you generally see in terms of one client, one lawyer, or is there an entourage?
It does vary. I think there's more of a move towards an entourage. I think the numbers are growing recently, which I think is a good thing, because the more people you've got invested in the day, the more likely it is to settle, the more effort everyone's putting into it.
Yeah.
When it's obvious that there are a number of stakeholders and a lot of people involved, and the lawyer comes along with just one person from the client, I do think, are they just ticking the boxes? Are they just going to go through this exercise? And they always say, oh, so other people are available at the end of a phone, but it's not the same. They've not got the same investment in the day.
Yeah.
So yeah, I think there are increasingly more people involved in a mediation, which for me is a good thing.
Okay, great. Next question, a bit of a funny one, but is mediation more of an art or a science? Claire, where do you come out on that?
Both, I think, is the answer, because I think
See the perfect mediator.
I think it's quite scientific in the way the law operates. So, if somebody wants something that's completely not available to, so for example, if somebody wanted to commit a crime via admit to a crime or something in a mediation, they couldn't do it. But so the science bit of the law is there, but also the science of psychology is there between the parties, and I think that's always very interesting, how people react to various situations. But I think then the art of that is understanding people. So you can frame it in as many psychological systems as you want, but understanding people is the bigger thing, and how people react to various situations. I think sometimes you've got to be a bit creative when you are trying to assist people come to an agreement where they have been entrenched, especially further down the litigation system you are. A lot of money's been invested in the litigation. There's probably things that have been discovered that people didn't want to be discovered. So I think that the art side of it there is to try and make people see the other party's point of view, and I don't think that is scientific. That's more of understanding human beings.
Yeah. Okay. No, good answer, Jeff.
It's as expected, a very good answer. I don't think I could add to that, Stuart. I mean,
Yeah.
Claire said exactly what I would have said. It's both. It's for the reasons that she's identified.
Yeah, no, totally agree. In fact, I did a mediation a little while back now. It was a Section 20 major works dispute, and there was 25 tenants on one side and 3 housing association representatives on the other side. And it was online, so it was a bit of a administrative managing issue. It was the classic issues. The housing association wanted to replace a roof for about £150,000, which was going to be split with the tenants who didn't have the money to pay for it. And all the tenants were arguing that there had been poor maintenance on the roof, and that's the reason the roof had to be replaced. So it was the council's fault. And there was obviously ripe opportunity for settlement in the middle. But the guy that who was in charge of maintenance for the housing association was part of the mediation. He was adamant that they weren't going to compromise because he felt that he'd done his job properly. And my view, definitely both the science and an art, but on the art sort of psychological side, the issue I had was trying to break down the issues for the surveyor who was entrenched in his position, and he was a very experienced guy, and it was very much sort of, you understand how this works and you see how things are, and let's see if we can move it on. And it was really concentrating and focusing on him to try and find a solution, and thankfully we did. So it is a real art, isn't it, to understand people and have that nuance. So that's good. Thank you very much. Next one is some big misconceptions about mediation that you encounter, either from clients, lawyers, or the wider legal system. Jeff, what do you think?
I think the biggest misconception, and to some extent it touches on what I said before, but the biggest misconception is that the mediator is there to make a decision. People, however much you tell them in advance, they think that the mediator is the judge, that the mediator is there to make a decision. And again, in my pre-mediation chat, I always make it clear to the parties. I mean, really, they're lawyers. If they represented, their lawyers ought to have made it clear to them well before that stage. But I always make it clear in the pre-mediation chat that it's not that I don't make any decisions. And what I often say is I'm actually the only person in the room who isn't making any decisions, because I'm just here, and obviously I explained that my role is just to facilitate negotiations and try and enable the parties to get to a deal. But I still find that parties are thinking that they need to persuade me of the value of their case, and they're still treating me as if I were the judge. And again, I mean, I explained to them that in a different scenario, they might come across me, obviously not in the case of mediator, but they might come across me as a judge, and that the role I do there is a very different role to the role that I'm doing on the mediation day. But for me, that's the big misconception that we as the mediators are the decision makers.
Yeah. Claire?
I echo what Jeff has said, but the other one is that mediation is a weakness. That any form of negotiation is showing weakness of your case. And again, as either a mediator or acting for the parties, you've got to be explaining this time and time again to people that no, actually it's not. It's going to save you an awful lot of money in the end. Usually is the way I try and deal with that particular problem.
Yeah. Okay. I mean, the next question is actually probably the same question as the previous one about myths you love to bust, and I think you probably covered that. I'm not here to decide, and it's not weakness. So I'd perhaps skip over that one. What do you think are the most important ingredients for a successful mediation, and where do you think parties or advisors go wrong in a mediation that militates towards not settling? Jeff, why don't you start?
Okay, all right. I think for me, the big thing that parties need to remember is that a mediation is a commercial negotiation, and some lawyers get that, and some don't. I have to say, without wanting to be disrespectful to your profession, Stuart, barristers tend to be the ones who are the people who are more likely to turn up with lever arch files of case law and skeleton arguments and want to discuss the law. And whilst, of course, the law is relevant, the reality is that any relevant and persuasive law will already have been articulated before the mediation day, and it will have already been put in correspondence. So there should be nothing new in there. But I find that sometimes I have to let the lawyer, as I say, invariably the barrister, have their say about the law, and then sort of say, well, that words to the effect of, that's all very interesting, but remember what we're here for today. We're trying to negotiate a commercial deal, and what I find is that it's sometimes quite difficult to persuade lawyers that what they need to be focusing on are the commercial levers, the things that are going to really touch a nerve and that are going to persuade the opposition to change their expectations. They're not going to be persuaded by legal arguments and case law because they already know that before we've turned up.
Yeah. Yeah.
And so that for me is where parties or advisors do sometimes go wrong. The law is relevant, but because it shapes what the parties are likely to get if the case were to go to court. But a mediation isn't a rehearsal for the trial.
Okay. No, great. Thank you, Claire.
I think again, Jeff's hit the nail on the head there with those issues. I think one of the things that I like to see as a mediator, if the parties have been represented, is that the solicitors have advised their clients properly about mediation and how it works. So if you are going into a mediation with the parties understanding that it's a commercial decision, that they could get rid of it on the day, that they're going to save lots of money, they're going to save lots of stress, and they could get rid of that mediation, that litigation on the day. That's really helpful as a mediator because you're almost pushing at an open door with both parties then. Although saying that, I've seen really entrenched parties come together, but it is always easier when the clients understand the process of mediation and how it works.
Yeah, I think it's invaluable. I mean, the power of saying to people, tomorrow morning you can get up with this behind you, with a settlement done, or you can look into the future of 12 months of aggravation, cost, and hassle while you continue to fight this dispute. And particularly for businesses, the opportunity cost is enormous because rather than focusing on looking forward and developing and growing your business and making money, you're looking backwards trying to resolve historic disputes. So I agree totally. I think the power of that statement is profound.
Sorry, Stuart. The other thing also is, especially when you've got businesses with very deep pockets who perhaps aren't as easy to get litigation fatigue, actually the managers and the directors that are having to give instructions and taking the time out of their business days, that's one of the biggest pressure points that I find. And once they understand that would stop, that is a very big pressure point that sometimes works.
Yeah, absolutely. Okay, no, good, very good answers. Thank you. So, quick fire questions. What's your favourite type of dispute to mediate, Claire? What would be your
contentious probate, actually?
Oh, really?
Yes, I think because you get people that are very vulnerable, very grieving people, and you're able to then assist them to a commercial decision, which is always been my favourite. It's a look of relief on these individuals' faces when that happens. I always find commercial mediations, unless they are, of a partnership fallout or a quasi-partnership fallout, they're not very emotive. There's very often that they very often can be actually settled with or without prejudice meeting, unless they are of that more heartfelt kind. So I think that would be my favourite, is contentious probate cases.
Okay, and Jeff?
I would say I don't necessarily think I've got a favourite, but if you're pushing me to choose one, I'd say probably professional negligence claims, and not dissimilar for the reasons that Claire's given in relation to contentious probate. But I often find that a professional negligence claim involves a claimant who just feels let down, and just wants the other side, if it's a solicitor or an accountant or surveyor, just to acknowledge that they got it wrong, and that that has caused loss and stress and heartache, and I think it can be that sort of coming together of minds, an apology or an expression of regret, however it's phrased, is often the relief that the claimant really wants. And once they get that, and they see that the solicitor or the professional is human and says, we should have done this better, sorry we let you down, that often can open up the discussion and lead to settlement.
Yeah, okay, that's interesting. And I know you did a probate mediation for Mediator Locator recently. I remember when you were appointed, you said that they're more difficult when they're done online rather than in person. What sort of, just on that specific point, Jeff, what additional challenges did you see by doing it online?
Um, well, yeah, I mean, let's talk generally rather about that
Of course.
mediation
Yeah.
in particular. Um,
Yeah.
I mean, it's the obvious thing, really. The same dynamics that come into play when you're deciding whether to have a meeting online or in person. As a mediator, I like to be able to feel the room and to speak to the people and to see their body language. And I think in a contentious probate mediation, as that one was, that becomes even more important. And clearly, Claire's got a lot of experience with contentious probate mediations, but it's much you can get a much greater investment in the people and they in you if you are in the room together. And also it enables you to have those chats about the coffee and the biscuits and all that
Yeah.
kind of thing that you can't put a value on, but they help so much to enable the parties to have confidence in you. And yeah, so it's just that kind of feeling the room, reading the room that makes it so much easier in all mediations, but I would say particularly in something like a contentious probate mediation, and the one you're talking about, Stuart, one of the parties was a couple that were quite old. So
Yes.
again, although in that case there was a very good lawyer who was able to um, deal with all the technological challenges, I felt that if I'd been in the room, it would have been easier and smoother for them as much as for
Yeah.
me.
Yeah. Okay. Very good. Um, can you share a moment where a mediation has achieved an outcome that you feel litigation wouldn't have been able to have achieved? Claire, have you got any examples of that?
Um, oh, so many. It's so many over the years. Um, it's the relief, I think, on people's faces. A couple of defamation ones I've done recently. One in particular I'm thinking of. Um, we actually got a heartfelt apology from the person that had been carrying out the defamation stroke harassment of my client. This is when I was acting for the client, not as a mediator. And the relief on that's all my client wanted was an acknowledgement that he wasn't what was being alleged.
Yeah.
And we couldn't have got that from a court hearing.
Yeah. Yeah. Absolutely. Absolutely. Jeff, what about your thoughts?
Yeah, I'm thinking back actually to a contentious probate one that I did a few years ago, where the testator had left different parts of her large and complicated property to different members of her family and to different children. And the siblings, they all detested each other and were arguing over
Family,
everything.
then.
Yeah, yeah. There were a number of siblings and quite a complicated family history, as you often find in these things.
Yeah.
Um, and they were arguing about everything. And it was obvious that the reality was that if the case had gone to court and there had been a determination about various aspects of this property, um, in reality, the value of the property would have been undermined. What it actually needed was for everybody to work together in terms of coming up with something to deal with this very valuable property. It was very valuable as a whole, but not valuable when broken up. So we actually got to a point, and this only sort of broke through towards the end of the day, where effectively a joint venture was agreed between the siblings as to what they would do by working together to get the best value from this property. Um, and it was amazing, really, that they all were persuaded of the value of doing this, and they all agreed to put their difficult history behind them for the purposes of this settlement, and we got to a deal. And as it happens, one of the solicitors is somebody who's instructed me regularly, appointed me regularly. And a couple of years later, I said to her, Whatever happened? Did it work or did it break down? She said, no, it worked. She said, and they did it. They sold the property. They all did extremely well out of it. She said they're still not really very friendly with each other, but they all got a lot more from that day than they would have done if they'd gone to court.
Fantastic. So they're not sitting down to Christmas lunch every year, but they'll probably be able to afford to eat out on Christmas Day thanks to the mediation process.
That's a good way of putting it. Yeah.
Yeah, excellent. Just conscious of the time, so I'm going to make this the last question, if I may, which is, what would you say to a client or a lawyer who's still reluctant to use mediation, or they're worried that it might show weakness? Claire, where would you go with that one?
Well, I think a lawyer who is worried that it shows weakness, it concerns me a little that they don't understand litigation and the whole without prejudice regime. And I would try and just outline in a basic explanation about the benefits of mediation, how it is being pushed by the courts more and more. So we're coming to a situation where in England and Wales where we are closing in on other jurisdictions who have mandatory mediation. Now, I'm not saying that I think that mandatory mediation is a brilliant idea, because I think it takes away the free will and the choices that people can make. However, I do think the pressure being put on parties to mediate is important, and I think in order to persuade people in order to mediate, I think we just need to look at things like Churchill and Merthyr Tydfil, where the court was absolutely adamant that the parties need to at least try, and so put those kind of pressures onto bear people that think and say you really do need to look at this as a viable option other than continue with litigation.
Yeah, absolutely. And Jeff, what do you think?
Yeah, I'd agree entirely. And just sort of picking up on that, what I would say to the lawyer or the party that's reluctant is almost to hide behind cases like Churchill and the current thinking, to say, well, so when they're writing to the other side and offering a mediation, to say we're confident in our case and we know we're going to win. However, we're mindful of the current authorities and the move towards mediation. So, in other words, to hide behind that, so that if they think that offering mediation is a weakness, and I don't think it is these days, I think we're long past that. But if there is that concern, then that's a way to deal with it. I think the other thing that I do try and do if I come across a lawyer who doesn't want to mediate, is to find out why, and sometimes it's just because the lawyer's not been in a mediation before and doesn't want to feel exposed. So, as a prospective mediator, I'll sort of say, well, look, don't worry about that. I will ensure that you're not exposed in terms of process, and I'll guide you through it.
Brilliant, excellent. Well, I mean, that's been really fantastic. Thank you both so much for your time this morning and for some great answers. And to the people listening, you can see the quality of the mediators we have with Jeff and Claire, and we've got 28 other people who are of similar expertise. So please do mediate. It's definitely the way forward. And if you would like to find out more, mediatorlocator.com's got a lot of information on the website. And if you need a mediator, please get in touch, because we'd be delighted to help. Thank you both very much. I really appreciate your time.
Thanks, Stuart.
Thank you.